Welcome to the session. It's going to be a very interesting session, a lot of great speakers. And I'm Dr. Judith Preston, Deputy Co-Chair of the Environmental Law Committee of Law Asia, supporting this event along with partners including ARIEL and UNEP. Very pleased to moderate this session on South Asia and constitutional rights regarding the environment. I'd like to begin this session by acknowledging and thanking Indigenous, minority and local communities all around the world, working tirelessly and often at great risk to protect the environment through their knowledges and practices at the interface of customary and non-customary law. I welcome any elders and community members from those groups who are present here today. This event celebrates the 20-year anniversary of the Montevideo Programme, developing and for the development and periodic review of environmental law. In March 2019, the UN Environment Assembly adopted the 5th programme as part of a 10-year intergovernmental programme on supporting countries in the Global South to develop and implement the environmental rule of law, build capacities and contribute to the environmental law dimension of the 2030 Agenda for Sustainable Development, running from 2020 to 2029, and UNEP is the secretariat of this programme. The environmental rule of law provides a framework for addressing the gap between environmental laws and their implementation. It strengthens the rule of law more broadly, supports sustainable development, protects human health, contributes to peace and security, and human, environmental and constitutional rights. Many countries are trying to strengthen the implementation of strong environmental laws, but there are backlashes, including those suffered by environmental and human rights defenders who are targeted, injured or killed. Another problem is funding for civil society is often restricted or unavailable. These problems occur both in Global South and Global North of nations. The strong drafting of and implementation of the environmental law, rule of law principles in national and subnational legal frameworks is a challenge for all countries. Implementation of environmental and human rights laws can be hampered by lack of political will, low funding and corruption. Another is the absence of a regional environmental and human rights court in the Asia-Pacific region, which can be accessed by individuals and community groups along with states. Effective ways of addressing these challenges will undoubtedly be discussed today. In this session, we'll hear from speakers about countries in the broad South Asian region, including Sri Lanka, India, Bangladesh, New Zealand, and Myanmar, which have embedded environmental rule of law principles in national laws, including constitutions. This has resulted in the strengthening of environmental and human rights protection for natural and cultural assets, including rivers, forested areas, watersheds, and sentient and non-sentient species. How countries can protect these assets from climate change will be discussed as well. I'm only going to give the briefest of details about the speakers because the details are in the program. And just remind everyone that you can put questions in the chat box, and I think the question and answer function as well, and just suggesting that if speakers could provide their contact details if they're comfortable in case we don't get to questions and people want some answers. And also I'd remind the speakers of the 15-minute limit. So our first speakers are Asanka Berdurasinghe, I'm sorry, that's the wrong pronunciation, is a senior lecturer at the Faculty of Law at General Sir John Kotawalara Defence University in Sri Lanka and currently a PhD student at the Macquarie Law School, and Dr. Michelle Lim, who's a senior lecturer at the Centre for Environmental Law in Macquarie Law School. They'll examine the concept of legal personhood in the context of rivers in South Asia and how South Asian culture, tradition and religion engages with relational understandings of the interaction with more than human communities. The presentation will examine how traditional stewardship practices can develop future ways to develop relationships with nature. Then in the context of rivers, an explanation of how Indian, Bangladeshi and Sri Lankan constitutions and legal systems have and can incorporate understandings of personhood in defining sustainable relationships with rivers. I welcome our esteemed speakers.
Thanks, Judith. And thank you, Asanka, for sharing screen. So as Judith has already mentioned, this is the title of our presentation today, and Asanka will go to the next slide, which is our acknowledgement that we are speaking to you from the unceded sovereign lands of the Wadamadugal clan of the Darug Nation. We're on Wallamada. We pay our respects to elders past and present for sustaining land, waters, country since the beginning of time. And we're going to look at a range of rivers today, and going on to the next slide. And clicking again, we're drawing from a paper that Asanka has led really well. Don't be fooled by the date, 2021. I think it goes to press as we speak, probably in the next week or so, and drawing ultimately from this paper, but also seeking to draw links with environmental rule of law. As you will see on the next slide, we are quite familiar with the concept of the rule of law. We'll start talking through environmental rule of law, and Asanka will talk through what it means in 3 different South Asian jurisdictions. So next slide, please. We're quite familiar with the concept of the rule of law, dating back to the Magna Carta, the idea that everyone being equal under the law, conceptualized quite nicely in this definition here, that all citizens, including those in power, should be fairly and equally ruled by the law. But what does environmental rule of law mean? Moving to the next slide, the IUCN World Declaration on Environmental Rule of Law seeks to flesh out the principles, the understandings, but also the implementation mechanisms around what environmental rule of law might mean. So in some ways, going back to the previous slide, what environmental rule of, that's fine, the next one. What environmental rule of law helps us to question is who are the subjects of law, but also what is law, whose law is relevant, and key principles, as you will see on the next slide, that come out of the environmental rule of law, the Declaration on the Environmental Rule of Law. Many 13 principles in the Declaration on Environmental Rule of Law. We've drawn out 4 here that are particularly relevant. Principle 1, obligations to protect nature. So that framing in itself, very much bringing in Indigenous worldviews of obligations to nature rather in terms of individual rights or even rights of nature. However, principle 2, we see the language of rights as well. Not only rights to nature, but rights of nature in addition to that. And particularly in our current context, as we're just about to discuss, more importantly, the rights of nature. Principle 7, in terms of intragenerational equity, but also included in the declaration principles of intergenerational equity, being key to a lot of the principles and discussion that Asanka will lead us through. And also importantly, principle 11, which recognizes Indigenous and tribal peoples and contributions in law that have occurred since the beginning of time. So I'm excited to hand over to Asanka, who will talk us through how these discussions of legal personhood, as it relates to rights of nature, as it relates to rivers, how that's been explored by the judiciary in India and Bangladesh, and how it might be explored in Sri Lanka.
Thank you very much, Michelle. So as Michelle said, in exploring how different jurisdictions in South Asian region recognize legal personhood of nature, we refer to 3 jurisdictions: India, Bangladesh, and Sri Lanka. Now, when we are looking at India, India does not expressly in the constitution recognize legal personhood of nature or legal personhood of rivers. However, India recognizes these concepts, rights of nature, as well as the legal personhood of nature through basic 3 judicial decisions, which are delivered in 3 writ petitions filed by the petitioners in terms of Article 226 of the Constitution. The first case is MOHD Salim versus State of Uttarakhand and others. This case was filed against the pollution of the Ganga and Yamuna rivers due to industrial activities. And the petitioners claim that the government parties, they failed to take appropriate measures to clean up these rivers. In the judgment, the court referred to the religious significance of these two rivers, Ganga and Yamuna, and held that these rivers are worshipped by Hindus. And the court even pointed out that the Ganga river is considered Ganga Ma, or Mother Ganga, and held that rivers Ganga and Yamuna are breathing, living, and sustaining the communities from mountains to sea, and they must be recognized as living persons and living entities. The second case is Lalit Mihalani versus State of Uttarakhand and others. This case arises from a previous petition filed against the pollution of the Ganga River. And as a response to this previous petition, the court issued an order containing several directions which must be taken by the government authorities to protect the river. And these directions include taking legal actions against 180 polluting industries as well. However, these government parties, they failed to comply with this court order. The petitioners filed another miscellaneous application, which was entertained under the continuous mandamus. And in this miscellaneous application, the petitioners requested the court to declare the Himalayas, glaciers, streams, water bodies, etc. as living entities, legal persons, juristic persons. And the court the parents' patriarch jurisdiction of the court and held that the entire ecosystem associated with the Ganga and Yamuna river shall be recognized as legal persons. The third case, perhaps the most interesting one, is a recent case decided in 2022, April, very recent. And in this case, A. Periya Karupan versus Principal Secretary to the Government of Tamil Nadu and others. The petitioner, he was a government servant. He filed this petition because he was not allowed to retire. He was placed under suspension due to a pending disciplinary trial. And this disciplinary trial was related to an act by the petitioner where he granted a patta or a deed to a land situated in the Megamalai village, classified as a forest Puramboki land. I'm so sorry if I mispronounce the word Puramboki, but it means that the state lands, forest land state owned by the state parties or the government. And with regard to these lands, private deeds cannot be issued. But this is what the petitioner did. And as a result of this action of the petitioner, his pension was reduced from 1/3 as a punishment. And the petitioner filed the writ petition and claimed that his co-delinquents' disciplinary proceeding was dropped and quashed. Therefore, he is entitled to the same protection because according to the existing precedent in India, co-delinquents shall be treated equally. And the court accepted that, of course, they shall be treated equally, but held that the court has to take some reservation because this case, this act of the petitioner is concerned with the forest land. And then the court went on to emphasize the significance, importance of the nature, Mother Earth, and referred to the previous Lalit Mihalani case and held that Mother Nature is a living being with all the corresponding rights, duties, and liabilities of a living person. And then the court held that even though the punishments of the co-delinquents were dropped or quashed, a punishment must nevertheless be imposed upon this petitioner because he had committed an offense against Mother Nature, not anyone else, but against Mother Nature. Then when looking at the Bangladesh situation, in Bangladesh, legal personhood of nature is recognized in this case, human rights and peace for Bangladesh versus government for Bangladesh and others. This case was filed against the encroachment of the Turak River by the human activities, and the High Court Division of the Supreme Court of Bangladesh recognized the legal personhood of all the rivers in Bangladesh, including the Turak River in this case. And the court referred to Article 21 of the Constitution and held that the citizens, both the present and future generations, they have equal right to the natural resources of the country, and emphasized that there is an utmost duty on the part of the human beings to protect, preserve, and develop the nature as a guardian of a child strives for its utmost benefit. Now I will move on towards the Sri Lankan context. As Sri Lanka is considered, as far as Sri Lanka is considered, Sri Lanka does not recognize rights of nature or legal personhood of nature in the constitution or in any judicial decision. However, interestingly, Sri Lanka's understanding of nature are deeply linked to nation's history, culture, and tradition. There are so many instances, there are so many principles, there are so many traditions, there are so many practices followed by the people in Sri Lanka where the nature is considered on par with or even as superior to human beings. However, the modern environmental protection legal regime in Sri Lanka has lost sight of these traditional principles and ancient wisdom. The reason perhaps is that in the modern legal framework in Sri Lanka, the indigenous laws plays a very, very minimal role. They are applicable only with regard to a very limited number of personal matters to a very limited number of people. And the religious laws, on the other hand, they have mostly become obsolete. The legal system is dominated by two principal legal systems, Roman Dutch law and English law, which are brought into the island by its colonial rulers, and the environmental protection legal regime in Sri Lanka is developed during the colonial period as well as in the post-colonial period. So it basically reflects the Western legal philosophies, Western ideologies, and not the ancient wisdom of the country. So the question is, should Sri Lanka go back and re-embrace ancient wisdom? And we say, yes, Sri Lanka should. And citing Judge Veeramantri in the Gamsikawa Nagamaru's project case, the ingrained values of any civilization are the source from which its legal concepts derive and the ultimate yardstick and touchstone of their validity. The formalism of the modern legal systems may cause us to lose sight of such principles, but the time has come when these must be integrated into the corpus of living law. So we say that this is the right time for Sri Lanka to re-embrace ancient wisdom. So to conclude our presentation, true environmental rule of law means recognizing nature for more than its instrumental values, for its intrinsic values as well as relational values. And legal personhood of nature and rights of nature, they provide great legal avenues to achieve this ultimate objective. And in recognizing legal personhood of nature, the jurisdictions around the world can refer to its ancient wisdom, the values upheld by the indigenous communities, traditional knowledge, rather than sticking on to the Western legal philosophies, which are sometimes criticized as having the separation and hierarchical ordering of human and non-human beings in its very foundation. So that we finish our presentation. Thank you very much.
Thank you very much. That was excellent. We've got, I'm sure, lots of issues to unpack there, but what I thought I might do is get everybody to do their presentations and see how much time we have at the end. So our next speaker is Associate Professor Trevor Dale Winterbottom, who's a New Zealand-based academic lawyer at the University of Waikato in Hamilton. His topic is the Montevideo Programme in a domestic context, and his presentation will explore the relative influence of the Montevideo Programme in the context of environmental law in Aotearoa, which is commonly known as New Zealand, and future prospects for progressive reform. So welcome, Associate Professor Trevor Dale Winterbottom.
Kia ora, kia ora tātou, kia ora tātou katoa. Thank you, Judith, and also for the previous presentation on rivers, which was really fascinating. I want to take a slightly different approach and look at the influence relative of the Montevideo Programme in a domestic context. And as Judith's already indicated, I'm going to look at that from the perspective of the jurisdiction here in Aotearoa, New Zealand. Arguably, the programme has had a real impetus on law reform in New Zealand. The first programme that came out in 1982 was one of the catalysts for a real period of reform, environmental law reform in New Zealand. So in the late 1980s, or from the mid-1980s through to the very early 1990s, we saw groundbreaking statutes such as the Environment Act of 1986, Conservation Act of 1987, and the Resource Management Act of 1991, all being enacted. These are broad legislative provisions which provide for sustainability, and they do so via constitutional style framework statutes. And I say that from the context of a Westminster style constitution that is largely unwritten or unformulated together in a specific code, But what we have, particularly in relation to these statutes, is some really good, incisive commentary. For example, Elizabeth Fisher from Oxford, looking in particular at our Resource Management Act, looked at it in terms of difficulties of interpretation and came to the conclusion that with these broad framework statutes, one can only really get some real sense out of them if we approach them through the lens of constitutional interpretation rather than normal canons of statutory interpretation. More recently, our Parliamentary Commissioner for the Environment, Simon Upton, has come to the view that, again, the Resource Management Act is the closest thing that we have in terms of being a constitutional statute in the environmental sphere, in terms of promoting sustainable management of natural and physical resources. Now I'm going to turn and look at some discrete sectoral substantive issues before coming back to a more constitutional flavour. Firstly, I want to look at the legal responses to address the pollution crisis. In response to persistent issues regarding water quality across Aotearoa, New Zealand, arising primarily from the discharge of nitrogen and phosphorus from dairy farming activities, regional councils are now required by the National Policy Statement for Freshwater Management of 2020 to change their plans by including rules to regulate these discharges. To ensure that we have complete plan coverage across Aotearoa, the Resource Management Amendment Act of 2020 provides for a streamlined plan change process. And I'll comment about this later in terms of the procedural aspects. In some regions, the plan change process commenced earlier, and in the Waikato region, the catalyst for the plan change was the settlement of historic grievances by the Tainui, the indigenous people in the Waikato region, regarding the Waikato River catchment under the Treaty of Waitangi Act of 1975. That settlement resulted in the enactment of specific legislation, the Waikato Tainui Raupatu, or Waikato River Settlement Act of 2010. And that in turn underpinned the Healthy Rivers Plan for Change, which was promulgated in 2016 and seeks to restore and protect the health and well-being of the Waikato River so that it's safe for food gathering and swimming by 2096. You'll see immediately that the time span is somewhat long, and that in relation to SDG 6, we're going to miss that milestone by a considerable margin. That particular document is currently before the Environment Court on appeal and is not yet operative. So some work being progressed, but long timescales in relation to some of these issues. Next, I want to turn to legal responses to combat climate change. And here, following the High Court decision in Sarah Thompson and the Minister for Climate Change Issues, decision from 2018 of the New Zealand High Court, that successfully reviewed the Minister's failure to amend the 2050 target for greenhouse gas reduction following the release of the report AR5 by the IPCC. The government's response to that loss in the High Court was to enact the Climate Change Response Zero Carbon Amendment Act. That was to provide for a more robust 2050 target and for greenhouse gas emission reduction budgets and plans. The government's now announced its first 3 emission reduction budgets for the periods 2022 through to 2025, and they were announced earlier this month. However, the emission reduction plan to get to zero carbon by 2050 has been criticised by the scientific community. For example, Emeritus Professor Ralph Sims stated as follows in relation to those plans that have been released. There's little in the plan that is new, challenging and exciting as a way forward that will highlight New Zealand internationally. The ban on offshore oil and gas exploration, announced soon after this Labour government came to power in 2017, hit the world headlines Nothing is in this plan will have such international impact. And generally the flavour of the scientific commentary on the current emissions reduction plan and emissions reduction budgets is that there is nothing new here. It's a rollout of old policy and old technology and old techniques that have already been under discussion for at least a decade, if not longer. Turning next to biodiversity and the legal response to the biodiversity crisis. Halting the decline in Indigenous biodiversity has been a persistent and intractable issue in New Zealand since the publication of the first State of the Environment report in 1997. That position remains the same today. And despite a strong legislative framework that's been in place under the umbrella of the Conservation Act 1987 for protection of Indigenous biodiversity on the Crown Conservation Estate, which covers around 1/3 of terrestrial New Zealand, there is no effective legislative or statutory policy framework in place concerning the protection of biodiversity on private land. Primary statute governing biodiversity on private land is the Resource Management Act of 1991. Already touched on the point that it's a framework statute and that it depends on a hierarchy of standards, policy statements and plans being prepared to ensure effective implementation. While Section 6C of the Act provides for the protection of significant areas of Indigenous vegetation and significant habitats of Indigenous fauna to be recognised and provided for as a matter of national importance, to date no national direction has been provided via an operative national policy statement. Successive governments have attempted to prepare national policy statements for Indigenous biodiversity in 2001, 2011 and 2019. The current draft national policy statement remains stalled in a holding pattern for further public consultation, with the political promise that it should become effective sometime during this year. The stumbling block has been the intersection between environmental protection with private property rights, despite Section 85 of the Resource Management Act, providing emphatically that no interest in land is deemed to be taken or injuriously affected by reason of any plan provision put in place under the RMA. In the meantime, the Biodiversity Strategy 2000, which was prepared as part of New Zealand's national reporting obligations under the CBD, now more than 2 decades ago, remains in place as a source of non-statutory guidance that arguably does not have any normative effect in the context of New Zealand's current legislative and statutory policy framework. Now return to the constitutional theme and look at public participation and access to justice. And here thinking particularly around Rio Declaration Principle 10 and also Section 27 that provides for access to justice in the New Zealand Bill of Rights Act of 1990. Since 2010, there's been a greater uptake of privative clauses restricting judicial review remedies and ousting statutory appeal rights to the senior courts when statutes have been enacted, particularly in the environmental law field. One example of that is Section 5ZM of the Climate Change Response Act of 2002, which was inserted by that 2019 statute that I referred to earlier. That provision now provides that no remedy or relief is available regarding any failure to meet the 2050 target or any greenhouse gas emissions reduction budget or plan, except for the power of the senior courts to make a declaration. So effectively, Section 5ZM purports to exclude jurisdiction of the senior courts to grant orders for mandamus, prohibition, certiorari, or an injunction. Similarly, the freshwater planning process inserted into the Resource Management Act by the 2020 Amendment Act limits statutory appeal rights primarily to questions of law determined by the High Court. It removes effectively appeal rights to the Environment Court, and more importantly, it excludes further appeals to the Court of Appeal and the Supreme Court. these statutory amendments are regressive and diminish public participation and access to environmental justice. There is, however, some hope in terms of future prospects for progressive reform, and some hope that we can take out of how some of these perhaps less positive amendments have taken shape. So despite those current failures, we do have optimism. Firstly, in terms of the intergenerational reaction to the way that recent reforms have taken place. One of the primary movers behind the enactment of the Resource Management Act and the other statutory reforms in the late 80s and early 90s was Geoffrey Palmer, who was at that time first Minister for the Environment and then Prime Minister. He's returned to the issue of the environment, but from a slightly different perspective, working together with another academic, Andrew Butler, around a proposal for a written constitution for New Zealand that would actually include an environmental right in a proposed Article 26, that everyone has a right to an environment that's not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations. So that's an interesting development there from the older generation, but we gain also encouragement from cases like Sarah Thompson and the Minister for Climate Change. That action is perhaps the most well-known of the New Zealand climate change cases. It was brought by Sarah Thompson at the time when she was a law student, engaged by her public law studies and excited about climate change and environmental law. She was motivated to draft a statement of claim after having done the research to allege that the Minister for Climate Change had not taken account of AR5 in terms of the responsibility to keep New Zealand's 2050 target under review, and succeeded in the High Court in establishing those matters on questions of law. So the great encouragement that's provided by the system there. Equally, although we have the amendment to the Climate Change Zero Carbon Act, which was brought in those regressive restrictions on remedies that we can now get on judicial review, which is now reduced just to a declaration in the context of climate change, that hasn't dampened the appetite for climate change litigation. And we have a Maori elder or kaumatua, Mr. Smith, bringing in action against 8 of our largest companies, including the large dairy corporation Fonterra, arguing that this novel tort duty of care on the part of greenhouse gas emitters to cease or reduce their emissions by 2030 so that we can achieve zero carbon neutrality by that earlier date. Likewise, if we also look at climate change litigation, the interesting thing there is that it has encouraged and catalyzed a whole range of lawyers outside the normal cadre of environmental lawyers. And we find a whole range of commercial lawyers and general litigators now engaged in pro bono work on these cases. They've formed their own organisation, Lawyers for Climate Action New Zealand, and they've even been preparing research papers lobbying the Minister of Justice to amend the New Zealand Bill of Rights Act of 1990 to provide for a right to a sustainable environment, seeking to insert in the statute that everyone has the right to a sustainable environment that is protected for the benefit of present and future generations. And the interesting thing for that is that whilst we only currently have 2 environmental law Queen's Counsel practicing before the New Zealand courts, that lobbying letter to the Minister of Justice was signed by not less than 50 Queen's Counsel across a whole range of different areas of law. So the ability for these issues to actually galvanise both the older generation of academics, youth, and a whole range of lawyers, bringing into play those key elements in Montevideo that are seeking to underscore legal education and also to upskill and energize lawyers to fight for the environment. Arguably, it's working and it's in good health, and we have some positive things there that will hopefully change New Zealand law in a positive way for the future. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Thank you.
Thank you so much, Trevor. And I'm just thinking those New Zealand silks could reach over the ditch and get a few more signatories on that petition. And I'm sure that the barristers in Australia would be happy to join with their regional partners. So good, thank you so much. As I said, we'll come back to some of the issues raised there. And of course, you've got that famous Whanganui River that's got its own legislation similar to what Michelle and Sanka were talking about. And of course, we have it in the Yarra River as well, own legislation.
And the connection there, Judith, is both Australian and New Zealand, given that John Salmond, who wrote in his book Jurisprudence on Corporate Personality, was, I think, the first law professor at Adelaide, and then was then poached to become the first law professor at Victoria in Wellington. Oh, well, it's good. So many connections between our two countries. It's fantastic. All right. Now, the next speaker is Associate Professor Jonathan Lillib at the Australian National University College of Law in the ACT in Australia. And he's a member of the Indigenous Pa'o people of Shan State, Myanmar. And Jonathan, I mentioned at the outset, we were just doing very, very brief intros because I understand that the organisers have got all the details on their website. So Associate Professor Lillib's presentation will involve an explanation of the differences between the thin versus thick conceptions of environmental constitutionalism and thin versus thick conceptions of rule of law. The presentation highlights these differences for environmental concerns and cautions that there are some more promising than others for addressing environmental issues. In particular, the presentation argues for a thick understanding that enables determinations of legitimacy and actions towards the environment. And I'd like to welcome Associate Professor Jonathan Lillib.
Thanks, Judith, and thanks everyone for being in the webinar today. I'll acknowledge the traditional owners of the land here at ANU. So for the campus of the ANU in Canberra, it's the Ngunnawal and Ngambri peoples. And we acknowledge and pay our respects to the elders past, present, and those emerging. I'm going to share my screen. I have a PowerPoint, and let me just start. So ostensibly today, I'm talking about Myanmar, but in the process of doing that, I wanted to help try to provide some clarity about ways we think about environmental constitutionalism and the connection between environmental constitutionalism and environmental rule of law. And out of this, have a larger application for the audience in terms of thinking through the different permutations that exist in the world regarding these concepts. So what I have here on the slide is just a summary of the larger literature, environmental constitutionalism and environmental rule of law. Within the scholarship, there's a differentiation between notions of thin versus thick, and hence the framework and the title of the presentation today. These aren't categories. These are actually the opposite ends of a continuum. So in the world today, as of about 2017, out of 196 different countries, approximately 148 to 150 of them have some mention of the environment within their respective constitutions. I'm sure those of you in the audience recognize that not all countries are the same, and out of those 148 constitutions, there are very different approaches to the treatment of the environment. And so with the scholarship, we see these as falling on a continuum, a spectrum between these different extremes, between the thin and the thick. On one extreme, we have thin environmental constitutionalism, and this generally references the constitutions we see that deal with the environment purely in terms of governance. You know, they articulate rules of governance. They proscribe or prescribe the powers of the government, the limits of the state. They also articulate or express the types of institutions that the state will have to deal with environmental issues. In contrast to this, on the other extreme, we have states or countries that have thick environmental constitutionalism. And these kinds of situations involve the same elements as thin environmental constitutionalism in terms of rules of governance, in terms of giving descriptions about the powers of the state, or stating the kinds of institutions that are appropriate. But in addition, with thick environmental constitutionalism, you normally have some statement about rights. Right? If not a statement of rights, then there's a statement of values about, you know, what are the values that we want with respect to the environment? What are the rights that we associate in order to implement those values? And this kind of dichotomy, this kind of distinction between thin versus thick approaches has an analog within rule of law discourses. So in rule of law discussions, you'll see that there's a same distinction between countries that have thin rule of law and then countries that have thick rule of law, and that there's a spectrum of countries that fall between those two extremes. With thin rule of law, you see countries that generally focus on making transparent laws, that they make an effort to try and make sure that everyone understands what the laws are, and that they also make sure that there are institutions that enforce the laws. At the opposite extreme, we have thick rule of law. So these are countries that they have transparency regarding laws, they have institutions to enforce laws, but in addition, they try to express some kind of notion of values and rights, the principles that guide the country, and also the rights that allow people to defend those principles or those values in the country. Generally speaking, when we talk about thin versus thick, we see these underlying distinctions or contrasts between order versus legitimacy. So with thin approaches, there's a general attitude of or concern about the need for order, stability, whereas with thick approaches, there is very much a focus on trying to determine legitimacy about what are appropriate or inappropriate actions by the members of a state or a society. When we talk about these kinds of distinctions between thin versus thick, there are actually consequences. And in extreme situations, we see some dysfunction with both of these categories. So with thin approaches, with thin environmental constitutionalism and thin rule of law, we see extreme permutations where the law, without any kind of guiding principles, without any statement of rights, the law becomes an instrument of whoever is in power, right? And this includes constitutions, that the constitutions become an instrument of whoever is in power. And so this is where we get the scenarios. And I think many of you who come from Asia have heard of this term, rule by law, right? So that the law is whatever the person in power says it is. On the other side, with thick interpretations of constitutionalism and thick notions of rule of law, there's a different kind of a scenario. And in extreme forms of thick constitutionalism and thick rule of law, we have a situation where nothing is sacred, that the determinations or decisions or the judgments about legitimacy means that anything can become illegitimate. And that means the state, it means society, it means everyone is subject to being identified as being illegitimate. So in which case, there is nothing that really represents a reference point for authority in those situations.
Jonathan, just sorry to interrupt, but are you able to put that on full screen? Because people are finding it a little bit hard to read
It is on full screen. I do have it on full screen at the moment. Let me see if I can.
So,
Let me see.
I mean, I have had that problem myself before. Yeah, that's it.
Yeah.
That's better.
Okay.
Yeah, that's good.
Okay. All right. All right. So the question I'll pose for everyone in the presentation is, what's the connection between environmental constitutionalism and environmental rule of law? And for this, I think it's instructive to reference some recent examples. So this is where I do introduce the events that are happening in Myanmar, but I also compare it to, I think, a timely reference point in the situation of Ecuador. And the reason I borrow these two is that in my mind, they represent the two extremes of thin versus thick with situations that occurred at roughly the same time. So with Myanmar, you had a 2008 constitution, and with Ecuador, you also have a 2008 constitution. In addition, there were events that played out in Myanmar in 2021, as well as events that played out in Ecuador in 2021 that illustrate some of these connections between environmental constitutionalism and environmental rule of law. In the situation of Myanmar, it reflects or exhibits what we mean by thin environmental constitutionalism and thin rule of law. Specifically, that when we look at the text of the 2008 Constitution in Myanmar, you see that it doesn't really articulate any kinds of rights regarding the environment. It doesn't articulate any kinds of normative values about the approach to treatment of the environment. Instead, what you see is very much declarations about the powers of the state, about who has the ability to make laws or rules about the environment. And in addition, it also imposes duties on people to obey the laws regarding the environment. So here in the situation of Myanmar, the state is the ultimate owner of the land, and the citizens have the duty to obey the state. The consequences of this, I think we saw manifest in last year in the 2020 military coup. In this situation, what happened was that the military used its constitutional powers regarding states of emergency. The military declared a state of emergency, and on that basis overthrew an elected civilian government. And as a result, it effectively used the Constitution as an instrument of legitimizing military control. One of the results of this was that the military then proceeded to accelerate environmental extraction. It accelerated deforestation, accelerated mining, it attempted to accelerate exploitation of petroleum reserves. All of this is as a way of financing weapons acquisitions and also financing wealth generation mechanisms for the military generals. Compare this to what happened in the situation of Ecuador. So with the Ecuadorian 2008 Constitution, you see comparable declarations about the powers of the state, identification as to who gets to make the rules regarding the treatment of the environment. But in addition, in keeping with the notions of thick environmental constitutionalism or thick environmental rule of law, the Ecuadorian Constitution declares rights. It also declares principles about what is appropriate or inappropriate treatment of the environment. So here, specifically, the Ecuadorian Constitution asserts principles of sustainable development, intergenerational equity, free, prior, informed consent, and also recognizes that citizens have rights to these kinds of principles. In addition, it also declares rights of nature, right? So these are all very much classic symptoms or elements about thick approaches. Now, an illustration of the implications of this was in 2021 with the Los Cídros case. So in this case, there was the Los Cídros forest, there was a mining concession, there was a ministry that had issued exploratory mining permits. The Constitutional Court said that the constitutional reference to rights of nature or the enshrinement of rights to nature in the Constitution took precedent over the ministerial permits. And on that basis, the Constitution delegitimized the ministerial action. So again, this is a situation where consistent with thick approaches, you had the Constitution and the law being a way of legitimizing, but also delegitimizing anyone, including the state itself. So I'm going to wrap up here with a simple question for the audience. Given all the different kinds of permutations we see in the world of environmental constitutionalism and the different permutations of rule of law, and given the comparisons between countries like Myanmar with countries like Ecuador, which do you prefer? And on that basis, what's the choice that you're going to make between thin versus thick approaches to environmental constitutionalism and environmental rule of law itself? So I'll finish there, and thank you very much.
Thank you, Jonathan. That was excellent. Again, many questions arising. We do actually have, I think, some extra time because Dr. Khan seems to have been held up some way. So we will have some, so if anybody, any of the speakers want to add some additional comments, we do have some time. And I would sort of encourage people to put questions in the chat box, which I haven't seen so far. But one question I have for you, Jonathan, maybe is to just observe how easy is it to, you know, even if countries do have constitutional rights for nature or Indigenous people or more broadly to protect the environment, how easy is it to enforce those rights? I mean, do the courts have procedures that make it easy for individuals to go there without spending a lot of money? Are there companies that try and, you know, throw slap suits and other procedural hurdles in the way? My observation, maybe it's a little bit of that older generation's a bit pessimistic, but often these great laws and constitutions that you see, it's hard to actually get them having the protection on the ground because of all the obstacles. So, you got any comments?
Yeah, thanks for that. And that's an excellent question. And very much, I think, one that preoccupies everyone. It's ultimately law, norms. These are the kinds of things that are dependent upon the will of the political system, the will of the state, the will of society. And so without that will, then everything is just simply semantics. Having said that, what we're talking about, or at least what I was describing in my presentation, was that in contexts where there is will, why is it that we still see a contrast between countries that are, relatively speaking, successful at implementing environmental conservation or implementing the norms that have been articulated by the international environmental community? And so this is a situation where having the availability of rights, the availability of values articulated in some way in something like a constitution, at least provides, and this is an additional legal concept, access. It provides access to justice so that once there is will, or assuming that there is will, that people are then able to go ahead and articulate and express that will to take action regarding the environment. But very much true. On a global scale, the issue of political and social will is very much in question. And I think that becomes a much broader movement issue for the environmental community as a whole. So, thank you.
Thanks. Of course, you know, when people are trying to enforce these rights, they need generous lawyers and other types of experts to support them. So that's another issue, but not insurmountable. Michelle, you have a question. We were just going to say, because we have a little extra time, that if people want to put their hand up like Michelle has and ask some questions live, we welcome that. Thank you, Michelle.
Thanks, Judith. A comment and a question. So the comment being, thank you, Jonathan. That was the clarity with which you delivered that as a conceptual framework for comparative analysis for constitutions. You made me feel like I understand constitutional law when it's really not my area. So thank you very much. Now, given I now feel like I'm a constitutional expert, I was interested in that spectrum that you were highlighting, sort of that thick, thin, but importantly, that characterization of how thick constitutionalism has this clear focus on rights. So my question, therefore, is, given ontologies which emphasize obligations, have you, and perhaps Ecuador would be an example of that, have you seen constitutions where obligations have been entrenched in the constitution, or if they were, where would they fit on that continuum?
I mean, so, you know, this is that part of the discussion on rights versus duties, right? And, you know, and particularly with indigenous communities, there's been sort of this distinction between the two, and in some situations, a critique of that rights-based framework. And, you know, the argument being that with duties-based frameworks, it ensures a more, what's the word for it? Well, more universal dedication to environmental conservation. I can see that as being feasible or possible. However, you know, the concern that I would have is, you know, goes back to with the thin critiques, which is who gets to impose those duties. You know, because if they're going to be duties, there has to be some kind of accountability, and so that accountability presumably is going to be imposed by someone or something. And too often, what we see, particularly within more authoritarian regimes, is that duties are being articulated by the state, or they're being articulated by a political elite. And they're being imposed in a way that is binding upon the society, but not necessarily being binding upon the state or the political elites. So there's that kind of exceptionalism. So until those problems are resolved, then, you know, I see that there's definite challenges to sort of the duties-based framework, and some need to sort of take consideration then as to, you know, how do we go about implementing or proposing a duties-based approach. Having said that, you know, it's open for discussion. And once again, you know, if we go through the 148 or 150 different countries that have the environment within their constitutions, I have no doubt that there is some distribution of differences between those who are favoring more duties versus those who are favoring more rights-based approaches. Thanks.
So do any of the speakers have any issues with that they'd like to raise about other people's presentations, or any comments?
I think, Judith, just picking up on the sort of perspective on Indigenous rights, that can be quite a strong catalyst for change. But it does depend on there being mechanisms there. One of the interesting things, certainly in terms of how environmental laws been developing in New Zealand, has been the ability for Maori to pursue those historic grievance claims through the Waitangi Tribunal, special statutory tribunal set up and chaired by a High Court judge. When those matters are settled, they result in specific legislation to deal with transfers of assets, recognition of special relationships with places, and a whole range of things. But increasingly, they are intruding into the environmental field in that those special purpose pieces of legislation will have environmental provisions in them that will amend existing environmental statutes. And it's quite interesting to look at, say, our Resource Management Act, where there's been 60 amendments to it that have all derived from those Indigenous claims treaty settlements. And they've done a variety of things. One of the things that they've done is added to rights of public participation by providing greater depth on them. Both participation in terms of first instance hearings before local authorities, and then when matters get on appeal to the court, particularly the Specialist Environment Court, to have virtually an automatic right to join proceedings as a third party. Those are really quite powerful things. But one of the interesting things around that is that when these settlements are documenting in legislation what relationships are, the relationships that are often documented are ones that span time, that go through indigenous genealogy and relate to physical places, mountains, rivers, a whole range of natural physical resources, and relate to those geographical features as ancestors. So the concept that we've got, particularly on the Whanganui River, isn't something that's sort of unique and separate. It's just how that particular treaty settlement was articulated and developed in that piece of legislation. But in relation to a whole range of other things, what we're getting is concepts of co-management or concepts of co-governance, and that's increasingly changing the nature at which some of the lower level instruments, such as local authority policy statements and plans, are being prepared, because in terms of the commissioning committees, they're now constituted by equal numbers of Maori elders and elected councillors. So it's quite an interesting dynamic that's sort of working itself quietly in the background.
Michelle, did you want to add anything to that?
Asanka, did you want to? I would just add that my understanding, that's a really interesting development. And my understanding of some of the critique of the Whanganui case is the shift in the role of iwi in relation to having to, in some ways, have two representatives in relation to the Whanganui, as opposed to, and my memory is hazy on this, as opposed to management in the entirety through an iwi process. Is there perhaps a risk that inclusion ultimately means some form of watering down of Indigenous governance processes, or is that part of a challenge there?
I don't think so there. I mean, there are two trustees who are appointed to speak for the river. One is appointed by the Whanganui iwi themselves. The other trustee is appointed by the Crown. But what you have there is there's a duty of consultation with iwi under the Treaty of Waitangi, so the Crown can't just appoint anybody it wishes in terms of its appointee. So there's a strong dynamic there that influences who the Crown's appointee will be. The difference, I think, between, say, the Whanganui River, where you've got the two trustees who can speak for a corporate being, compared, say, to the Waikato River, which has got a co-governance arrangement there, is that arguably the Whanganui River settlement is much more powerful because the trustees are an external influence. You know, they make submissions on plans. They can exercise the third party rights in the Environment Court. They can initiate proceedings in tort for harm to the river. They can seek judicial review of decisions that might adversely affect the river in some way. So I think that there is, something quite strong there, even though it might appear to be narrow because you've only got 2 people speaking there, rather than, for example, in terms of the Waikato, having 8 elders who are appointed to various committees of the regional council in a co-governance partnership arrangement. So the 2 things are both very positive, but I think very different, and arguably giving personalities is the game changer, and one just wonders whether that is possibly the new normal under these Indigenous treaty claims settlements. It's just a matter of waiting to see what's going to happen with the next big settlement that sort of comes out of the process.
Thanks, Trevor. We have a question from Joseph Fallon, and I think Georgina was going to unmute as one of the participants.
Thanks, Judith. Actually, they have just put down their hand, so we can move to Abdullah Muhammad,
okay.
who has their hand raised. Abdullah, you should be able to speak.
Yeah, I would like to know, dear Daja, and many thanks all. And what I would like to thank is that you are improving a lot of things in environment. As observer of environment, my question is that many states still have a binding instrument like storms and dust status. And in this regard, it needs more rectification in disaster risk and strategy reduction in globalization. As special observers, I wonder risk inclusion, storm challenges for globalization crime or triangular borders, for example, have effect on triangular. Like in USA, we have seen that storms in Somalia and Kenya, we have, and Ethiopia, triangular borders, we have storms. What inclusion? Who should we blame? That's the question status we need. Whom should we blame? These natural disasters. What man-made plan do we have in process? Thanks.
So Abdullah, you talking about environmental crime? I think you know that you mentioned something about human rights and slavery in the chat box, but it wasn't quite a question. So maybe if anybody would like to comment on how you combat serious environmental crime, and which bleeds into human rights crimes, using constitutional rights, maybe the International Criminal Court as well. You want to make a comment on that? No. Everyone's too overawed. Well, obviously, you know, with environmental crimes, including destruction of heritage, there is one case in the International Criminal Court. So that is something that can be used, but it's very complicated. And unfortunately, I think many African countries have been, leaders and politicians from African countries have been targeted, maybe unfairly, because there are a lot of serious environmental crimes around, including human rights abuses. But there are obviously laws that deal with this in countries, but it's the same difficulty. Even if you have very strong laws, it doesn't mean that necessarily that people prosecuting officials will take the cases forward, and then it's hard to get evidence, hard to find witnesses that, if it involves government departments, that will stand up against it. So there are many problems, and this is why serious environmental crimes go unpunished. So, Jonathan, would you like to say something?
Yeah, I mean, so I will make, well, 2 comments regarding the question. So on one hand, there is an issue of causation, and then the second issue, which is evidence gathering. And so both of these are very much works in progress, not just within the environmental space, incidentally, but also within the human rights space and also in the humanitarian space. We have situations where different jurisdictions in different countries have systems regarding causation and evidence gathering, but at the international level, this is where things become somewhat tenuous. And it's very much within humanitarian and human rights spaces. We see with the International Criminal Court that one of the biggest struggles it has is about gathering sufficient evidence, and particularly evidence that is sufficient to prove causation. And that's something that I think is very much a work in progress. With respect to the environmental space, I think one of the things that is very reflective of this problem are the repeated attempts by the Pacific Island states regards to climate change litigation in various courts, not just international, but also domestic. And I know that with places like the United States and other countries that shall remain nameless, that one of the things that the court has stated, or the courts, plural, have stated on repeated occasions, is the question of, is there sufficient evidence to prove that, number one, the change in climate that's occurring as a result of the emissions, number two, coming out of a country, number three, like the United States. And so this is where the hurdle becomes quite difficult. I think this is where, incidentally, I think some energy deserves some dedication at domestic and global levels. There are entities like the Environmental Investigation Agency that does try to gather evidence, and it does try to gather evidence that meets some standard of causation. However, that's just one entity. It's a non-government organization. So obviously, those kinds of efforts could be supported by parallel efforts or coordinated efforts by other sources. And so I'll just leave my comments at that. Thank you.
I would comment on the fact that if we're talking about climate change, I have heard that Vanuatu is taking steps to make a reference by the General Assembly to the International Court of Justice to have an advisory opinion on the duties of states to its citizens in relation to climate change. Obviously, we all know that the International Court of Justice is not, well, I mean, it's the advisory opinion is there for instructive reasons and to be a powerful message to countries to follow suit, even though they can't be, the decisions or the judgments can't be enforced as such. The other thing I mentioned, and it's a little bit related to constitutional rights, is the very valuable roles of UN human rights committees and UN special rapporteurs that play a very important role in calling out and highlighting and putting pressure on governments, even if you don't have the laws and say, for example, with Indigenous people who don't often have the standing to get into courts if there are courts. Sometimes I mentioned in my opening remarks that we need a regional human rights and environment court in the Asia Pacific region. We have a group of Torres Strait Islanders, the Torres Strait 8, that are making a reference to the UN Committee on Human Rights, and the UN Special Rapporteurs on Human Rights and the Environment John Knox and David Boyd, are being very, very supportive of not only Torres Strait Islanders, but other Indigenous groups around the world to put amicus briefs together to try and make some inroads. If countries, governments won't pass the laws, they won't amend their constitutions or set up new constitutions. I mean, in Australia we have that problem, but that's another sort of avenue that I think maybe is not as well known as it should be, but it's definitely a good pathway to getting some progress. We did have some questions by somebody called Gabriela Kamara. Do they want to ask a question? Put their hand up and put their hand down. So maybe, Georgie, you could invite them to ask the question. But any other questions or comments? Because we're
Gabriela, you have the ability to unmute if you would like to ask your question.
Yes, can you hear me?
Yes, we can.
Okay, I was just asking a question. I think I put that on the chat, on the question box. In most African countries, there is no express provisions in the Constitution about environmental rights. I mean, and also the rights to protect the environment. So in the absence of those provisions, I just want to know whether the panelists can elaborate on the use of global human rights mechanisms to protect environmental rights and the possibility of a universal instrument on human rights and the environment. As you rightly said, you mentioned the work of David Wells on the environment and human rights. And there were discussion about the possibility of bringing a universal instrument on human rights and the environment. I don't know how far that process has gone. So I just want the panelists to elaborate on that.
Who would like to jump into the fray? Trevor, you look like you're ready to answer that.
No, I just appreciate a few more minutes just to think about that, Judith.
Okay. Jonathan, how about you? Yes, thank you.
Yeah, that's, oh, sorry. Yeah, thanks for that. I'm just reading the question box. So my comments or my thoughts on this, number one, there is significant work being done at the UN level. So we mentioned the Special Rapporteur on Human Rights and Environment, and they've done, and that office has articulated quite a number of guidelines regarding the connection between human rights and the environment, and in particular, the framework principles that connect the two together. Number two, and this is the cautionary part, is that as most people in the audience know, framework principles are non-binding. They're just simply guidelines. States are not obligated to follow them. Number three, human rights treaties are binding upon state parties, but I think most of us know that most states are not parties to, state parties to human rights treaties, with the exception of just a handful of treaties. Even in situations where states are parties to human rights treaties, we run into a situation where the obligations to the treaty are dependent upon the will of the state to go ahead and articulate them as domestic law or domestic legal obligations. And there we see quite a bit of variation or contrast from one jurisdiction to another. So not all, while we can see, for example, that the majority of countries in the world are state parties to the International Covenant on Economic, Social, and Cultural Rights, we can very much see that there is very much variation in terms of their ability or the degree to which they've implemented those rights. As a result of that, the consistency or the extent to which they can go ahead and connect the human rights treaties to environmental issues is very much open to question. And I think that is something where the efforts by the Special Rapporteur on Human Rights and the Environment, as well as the mutual efforts of the human rights community and the environmental issues communities could benefit from quite a bit more effort and energy. Is to, we've taken the first initial step of identifying the connection between human rights and environment. We now have to go through the process of going to the next step, which is making sure that they're being implemented and enforced within each country around the world. So thanks.
I would add that not every country can, even if they ratify, it doesn't automatically go into their system of law. And in Australia, we have to pass particular legislation. But that is not to say that you can't have courts that take notice of international principles, legal principles, or other cases. I know in New South Wales and Land Environment Court, there have been a few cases, the federal court as well. So that's another way that courts can build capacity between themselves, knowing what other cases and developments, and they can expand the rule of law, if you like. There is another question from Peter King, and I feel that it's directed to Trevor. What's the end game for assignment of rights to geographic entities in New Zealand, and what is the time frame? Thank you for that question.
I think the end game is that we are likely to see more things in that direction. That's my prediction. In terms of time frame, that would be hard to put a stab on, and the reason for that is that most of the large sort of historic grievances have been litigated or are currently being litigated. But I think what we might find is that sitting behind the settlement statutes, there are deeds of settlement with the Crown. And in many of those deeds of settlement, there are reservations. And what we might find is that there might be a litigation of those reserved rights by Maori coming in and looking at perhaps, say, at a co-management or co-governance arrangement and saying, well, this is working sort of reasonably well, but it's not good enough. We think that we could get enhanced protection through giving personality to a mountain range or to a river. The other interesting context of that is that the Whanganui River was new in terms of precisely what the statute provided, and you go and look at section 14 in that statute, and you look at the general power of competence in the Local Government Act of 2002 or the general power of competence in the Companies Act of 1993, and they are linguistically very, very similar. So it is a corporatization type of giving legal personality that's there. But having some recognition that people speak for parts of the environment, having guardians, is not new. And we've been doing it with lakes and fjords and part of the marine area in New Zealand since 1964. So it's a gradual development. It's continuing, but I think that we will see more of this kind of real personality being given to geographic features, and that then enables the elders, the kaumātua, to speak for the resource, and to speak for the resource on the basis of the genealogical relationship, and also in terms of the relationship with future generations. And that's one of the important things to think about when we're dealing with Indigenous peoples and Indigenous values and Indigenous rights. That temporal time scale horizon is often very, very different than ones that we get from just a purely sort of application of inherited English or Scots or Roman Dutch law in our systems.
Thank you, Trevor. I just wanted to ask a general question to the panel about, we've been talking about straying a little bit away from constitutional rights, and we're talking about rights for particular features like rivers, but whether or not we should look at more ecosystems rather than specific geographical features, as Peter King's question included. I think, for example, of the Water Act in Australia, and whether or not we should start again in terms of the Murray-Darling Basin, because the Water Act looks like exploitation to me rather than protection of that incredible river system. Michelle, you've got your hand up, so maybe instead of answering that question, you would like to make a comment or have a...
Thanks, Judith, and thank you, Trevor. I really liked how you conceptualized the understanding not only of relationships to environment, but how time and circular time comes into all of that discussion. And Asanka, to put you on the spot, but with a warning that I'm about to throw to you to put you on the spot, perhaps the Tamil Nadu case that you talked about raises in some ways the provocative question of, should there be limits to rights of nature? Is there the possibility that this concept is one that you can take and perhaps run with a little bit too far? That case, as you articulated so nicely, was a pensions case, and then suddenly the person being penalized because potentially infringing on rights to nature. So yes, perhaps if you could come in on that.
Yeah, that's true. That's the Tamil Nadu case, the judgment of the Madras High Court. It's about the pension, and the writ petition was filed because the petitioner's pension was reduced. But then the judiciary mentioned that, recognized that he shall be punished. He shall not be paid the entire pension because he committed an offense against nature. And it is, I think it's the first time that the Indian judiciary recognized that the entire nature has rights. Earlier, they have recognized the rivers have rights, but this is the first time where the Indian judiciary recognized the entire nature has rights. So in a way, I think, what you said is correct. But on the other hand, I think in the countries like India and as well as Sri Lanka, it's the judiciary which is playing a very vibrant role in protecting the environment. Now, if we take India, they do not have a specifically recognized right to environment, but they have a very, very wide and very conclusively recognized right to environment now, and it is basically developed by the judiciary. If the judiciary did not play that role there, they will not even have a right to environment, at least now. And the case is true with regard to Sri Lanka as well. In Sri Lanka, the constitution is silent with regard to any right to environment. It's the judiciary which recognizes a right to environment. And the other thing is, in India, they at least recognize the constitution, at least recognize right to life. But in Sri Lanka, there's no right to life, there's no right to environment. So the judiciary was in a very, I might say, unfavorable position. But through the existing rights, the judiciary recognized that the people have a right to environment. And also, recently, in one of the judgments delivered by the Court of Appeal in 2019, the Court of Appeal they ordered one of the former ministers in Sri Lanka to bear the entire cost of a reforestation program because he has been instrumental in that, in the destruction of that forest area. So in a way, while we can say that it's a pension case and the nature came out of nowhere to that perhaps, but I think it's good that the judiciary is acting a very vibrant role, particularly in the context of South Asia, in the countries like Sri Lanka and India. And to point out another thing, in the context of my country, 2018, there was a constitutional coup. There was an utter chaos in the parliament. The executive and the legislature, they were literally fighting over who must hold the power. And it's the judiciary who intervened and interpreted the constitutional provisions and held that the constitutional coup is wrong. So yeah, in countries like ours, specifically Sri Lanka, the judiciary's role should be very wide, and we shall be glad that it's actually playing a wide role. Yeah.
Thank you, Asanka. And just to note that Sri Lanka is going through a lot of turmoil.
Yes.
Yes. And hopefully Laurasia will make some statements, as they have done in the past, and in support of protecting human rights and the environment.
Human rights, yes, exactly. Thank you.
Well, we've come to the end of our session. It's been really fantastic, and I'm very, very grateful to all these brilliant speakers that have given up their time to prepare amazing presentations and raise probably more issues than we can deal with today. And thank you also to the participants. They've provided some great questions. I'm sorry that we couldn't get to all of them, but hopefully you've seen the email addresses in the chat box, but you can look up the speaker details and maybe email them to their work addresses. So thank you everyone for participating, and I think we've got a film now that's ending this session. Thank you to Georgina Lloyd that was assisting me, and Rocky and Paolo as well from ARIEL and the UNEP. Great, thank you. Thanks, Georgie.
Thank you very much, Judith, and a big thank you again to all of the speakers and the audience as well for supporting this session. So we are going to now take a break, and we are going to move to our 5th session in this mammoth 24-hour celebration of environmental rule of law that will start on the hour. The 5th session is going to look at let me get my guide up. The 5th session is going to look at the role of Montevideo to advance environmental rule of law in the Middle East and North Africa. So we're slowly moving away now from the Asia Pacific region, and we're moving towards the Middle East and North Africa. And we are going to be running this session with the support of the Environmental Law Network from the Middle East and North Africa. So please do come back and join us on the hour for that session. And in the meantime, we have a couple of videos in which we reached out to a number of eminent experts in environmental law to share with us what they thought was the greatest achievement in environmental law over the last 40 to 50 years, and what is the remaining challenge for the decade and decades ahead. So we're going to play that compilation for you now. Thank you again. See you at the hour.